Hello, good day. Welcome once again to another episode of JMVL Case Digest Kwentuhan Sessions or Kwentuhan Sessions JMVL Case Digest. This is episode 21 of our Kwentuhan. So 21 na kasi nga naka 420 na tayo as of recording. And for this 21st episode, we'll be having People of the Philippines versus XXX. GR number 243988, decided August 27, 2020. So this is a criminal law case under the topic of rape and statutory rape. Okay, so for the facts of the case, AAA, a 29-year-old woman, and XXX were distant relatives and longtime neighbors. Sometime November 2008, BBB observed that her daughter, so nanay si BBB, AAA, was constantly feeling sick and vomiting. Thus, BBB asked AAA, who confessed her pregnancy and pointed to XXX as the father of the child. Together with AAA's father, BBB confronted XXX before the barangay. Okay, so hindi naman po Serex 'to. Nagkataon lang talaga, puro tayo puro, ano 'to, initials lang kasi, rape case nga ito. So, later on you'll know why, the names are confidential, okay? Thereat, XXX expressed his willingness to marry AAA. However, with AAA's father seething in anger, the plans for marriage did not push through. Still, XXX promised to support the child. Soon, AAA gave birth to a baby girl. But after more than 4 years, or on April 13, 2013, AAA was pasturing a cow when XXX suddenly dragged her into the shrubs. So doon daw sa madamuhan. Okay, kinaladkad daw siya doon. XXX removes AAA's underwear, covered her mouth with clothes, and went top of her. Thereafter, XXX inserted his penis into her vagina. So, rated SPG po pala to, nakalimutan kong sabihin. So, pakinggan lamang kapag kayo ay mag-isa or kapag naka-headset. Pasensya na, late advice. Okay? AAA resisted and hit XXX with a piece of wood and stone. Later, AAA disclosed that she had sex with XXX several times, but he threatened to kill her if she told her mother. So maraming beses na pala mayroong nangyari sa kanilang dalawa, si AAA at si XXX, pero may pagbabanta involved coming from XXX, the accused. Okay? Thus, XXX was charged with rape under Article 266A, paragraph 1D of the Revised Penal Code, and sexual abuse under Section B of RA 7610 before the Regional Trial Court. In his defense, accused XXX admitted having sexual intercourse with AAA in November 2008, but alleged that they were lovers. So, anong klaseng defense to? Ito yun, di ba? Sweetheart defense. Okay? On July 4, 2016, the RTC convicted XXX of rape in criminal case number CBU 101439. It considered XXX admission and gave credence to testimonies about AAA mental disability. Okay, so makikita nyo na kaya naging confidential yung pangalan ni AAA kasi may mentally challenged itong si AAA. Kaya hindi pinapangalanan. Kapati yung kanilang mga magulang. Okay, na si BBB. Okay, XXX was sentenced to suffer the penalty of reclusion perpetua without possibility for parole in accordance with Republic Act 9346. The accused is ordered to pay the offended party AAA civil indemnity of 75,000, moral damages of 50,000, and exemplary damages of 30,000 with interest of 6% per annum. XXX appealed to the CA. He contended that AAA consented to their sexual intercourse. Also, XXX insisted that AAA is not a mental retardate. On June 29, 2018, the CA affirmed RTC's findings that XXX is guilty of rape but modified the award of damages. Hence, this requires on the ground that the prosecution failed to establish XXX guilt beyond reasonable doubt. He interposes the sweetheart theory and claims that the sexual intercourse was a free and voluntary act. Okay? So, um, again, AAA was raped and through the fact, sinabi na mental retardate si AAA. Therefore, ang contention is that on the side of XXX is number one, AAA is not a mental retardate, and number two, they were sweethearts. Okay? So before we go to the issues, hindi ba kayo na-curious? Kasi ako na-curious ako kung bakit yung accused ay naka-XXX din. Okay? Madalas, di ba, kapag ganito, kahit rape case, yung pangalan ng accused naka-spell out or um, sinasabi ko anong totoong pangalan niya. But in this case, XXX. So, bakit hindi siya pinapangalanan? Okay? Kaya dahil na-curious tayo, siyempre tumingin tayo sa full text. Okay? Again, it's always advisable to read the full text and you would also learn from the footnotes. So, sabi sa footnotes ng case na to, ng full text case na to, bakit hindi pinangalanan si XXX, okay? Sabi is, at the victim's instance, or if the victim is a minor, that of his or her guardian, the complete name of the accused may be replaced by fictitious initial or his or her personal circumstances blotted out from the decision, resolution, or order if the name and personal circumstances of the accused may tend to establish or compromise the victim's identities in accordance with the amended Administrative Circular 83/2015. Okay? So, hindi lang pala nangyayari na yung victim yung nagiging confidential yung pangalan. Maaari din pala na yung accused maging confidential din yung pangalan kasi since in this case, babasahin natin, they were distant relatives and long-time neighbors. So, mate-trace back dun sa victim kapag in-spell out yung pangalan ng accused. Okay? So, wala ng sense, 'di ba? Kapag yung pagiging confidential ng pangalan ng victim kung ma-spell out naman daw yung pangalan ng accused. Okay? So, wala lang. Trivia lang naman 'yan. Okay? So, balik tayo. Let's now go to the issues of the case. Whether or not AAA is a mental retardate, making XXX is guilty of statutory rape. Okay? So, if you would go back to the facts, it is said that AAA is a 29-year-old woman. However, it was found out that AAA is a mental retardate. However, again, XXX is disputing that AAA is a mental retardate and therefore he would not be guilty of statutory rape. And kaya pag hindi siya guilty ng statutory rape or hindi siya mental retardate, papasok yung consent, tatama yung sweetheart theory niya. Okay? So yun. Kaya um, importanteng malaman kung mental retardate nga ba si AAA. Get? Then number two, whether or not XXX sweetheart defense should be given credence. Okay? Papaniwalaan daw ba natin si XXX na mag-sweetheart sila? But, issue number three, whether or not XXX can be charged and guilty of qualified rape. And number four, whether or not the phrase without the possibility of parole is for parole is proper. Okay? Kasi meron dun nakalagay sa decision na without possibility for parole. Kailangan pa daw bang i-spell out yun or kailangan pa bang sabihin sa decision kung merong parole o wala? So, technicality wise pero syempre para nandiyan ang Supreme Court para turuan ang bench and the bar. So, yun, kasama yun sa issue. Okay? Number 5, the last issue, whether or not the CA correctly modified the awards for damages. Okay? So, let's go to the rulings. Number 1, yes, AAA is a mental retardate making XXX guilty of statutory rape. Okay? Justice Mario V. Lopez, again, of course, this JMVL case, said that the crime of statutory rape is defined under Article 266, paragraph 1D of the RPC as amended by RA 8353 has the following elements. Number 1, the offended party is under 12 years of age, again under 12 years of age, and the accused had carnal knowledge of the victim. Okay? It is committed regardless whether there was force, threat, or intimidation, fraud, or grave abuse of authority, and whether the victim was deprived of reason or consciousness. Okay? It is enough that the age of the victim is proven that there was sexual intercourse. Okay? So, bakit importante na ma yung pagkaka-distinguish ng statutory rape? Kasi siyempre, kung hindi siya statutory rape, yung consent papasok, 'di ba? Whether or not there was consent. But if it is a statutory rape, therefore kahit merong consent or kung kahit meron mang consent pero dahil below 12 years old siya or mental retarded siya na below 12 years old yung utak niya. Therefore, wala talagang consent na nakuha. Okay? Justice Mario V. Lopez, even citing People versus Castillo. The court en banc settled that the crime is statutory rape when the victim has a mental age of a person below 12 years old. A person with a chronological age of 7 and a normal mental age is as capable of making decisions and giving consent as a person with a chronological age of 35 and mental age of 7. Okay? Chronological age meaning yung talagang birthday niya, 'di ba? Yung age niya, okay? Per birthday, pero yung mental age of course yung status or yung state ng utak niya. Okay? Both are considered incapable of giving rational consent because both are not yet considered to have reached the level of maturity that gives them the capability to make rational decisions, especially on matters involving sexuality. Decision-making is a function of the mind, hence a person's capacity to whether to decide to give consent or to express resistance to an adult activity is determined not by his or her chronological age, but by his or her mental age. Therefore, in determining whether a person is 12 years of age under Article 266A, 1, paragraph D, paragraph 1D, the interpretation should be in accordance with either the chronological age of the child if he or she is not suffering for intellectual disability or mental age if intellectual disability is established. So, sinasabi dito ni Justice Mario V. Lopez that there should be a consideration not only to the chronological or kung anong talagang age niya, and also the mental age, okay? Pwede naman daw na matanda na talaga siya pero yung utak niya ay pangbata pa rin and therefore could not give consent, okay? Here, Justice Mario V. Lopez said all the elements of the statutory rape were proven beyond reasonable doubt. Foremost, it was established that AAA is incapable of giving rational consent and has not reached the level of maturity that would give her the capacity to make prudent decisions, especially on matters involving sexuality. A series of psychological tests revealed that AAA is a mental retardate. So, meron naman palang test na ginawa. Okay, of course, yun yung unang pre ng prosecution, okay, in order to prove that there was statutory rape, syempre kailangan kayong proof, and the proof comes from the expert witness. Then the expert witness, of course, made examination and observation of AAA. Alam mo, para to prove that she is a mental retarded. Okay? The examining psychologist testified in open court that AAA has a chronological age of 29, but has a mental age of 6-year-old. Okay, of a 6-year-old child. So therefore, kahit 29 years old na siya, since mental retarded siya, having a mental age of 6-year-old, therefore pasok pa rin siya sa statutory rape. Okay? Kaya yung defense ni XXX ay hindi pwede, okay? Na hindi daw siya statutory rape. Okay? Since AAA has a mental age of 6 years old. Okay? Also, the trial judge had the opportunity to actually examine the demeanor and concluded that she is a mental retarded. Okay, so syempre, the court, especially the Supreme Court, di ba? The reason why they are not triers of facts kasi nga meron namang mga lower court na nag-try na noon, okay, na nakita na nila on their own observation, including the mental state of a witness. So, hindi na nila questionin sana yun, okay? Kasi nga, sila yung mas may dapat alam nun, okay? As the RTC aptly observed, the offended party, although 29 years old at the time of the alleged incidents, had the age of a 6-year-old, as attested by the psychologist who observed AAA and conducted tests on her. The psychologist further explained that because of her mental disability, AAA could not sense danger to her person and was easily lured or threatened. Her physical observation of AAA readily showed that the latter had such a disability. This belies the allegation of the accused and his witness that they never knew that AAA was mentally retarded, despite the fact that AAA was a relative and a neighbor. Okay, so paano mo hindi mo malalaman na may problema sa utak yung victim, magkapit-bahay kayo. So for sure na obserbahan mo na yan for a very long time. Dahil na-obserbahan mo na, pinagsamantalahan mo yung kanyang pagiging mental retarded. Okay, yun yung sinasabi ng court. Okay? Indeed, even the court could discern from the way AAA spoke and behaved when she testified that she had the mind of a child. AAA's manner and behavior, even at first impression, indicated her disability, and it was impossible for the accused not to have known that. So baka, well, wala tayo dun sa courtroom ng mga panahon na yun. Of course, nag-aaral tayo sa law school, pero siguro nakita ng judge, ni RTC judge, na batang sumagot, okay, baby talk or bata pa yung pagkakasagot niya, hindi pa mature yung yung pagkaka-deliver niya ng kanyang testimony, okay? So ayun, baka mamaya meron pa siyang ibang words, dun sa mga reproductive organs, okay? Hindi penis, hindi vagina yung ano, gamit niya kundi pangbatang term, 'di ba? So kaya gano'n, and siyempre yung demeanor or yung how she acted, nakita din 'yun ng RTC judge. Therefore, na-observe nilang na hindi nga talaga pang 29 yung acts pang 29 years old yung acts ni AAA, but a 6-year-old child. Okay? More importantly, the prosecution established that the accused had cardinal knowledge of the victim. Of course, this is to satisfy the two elements na nabanggit kanina. Na again, in order for there to be a statutory rape, dapat the offended party is under 12 years of age, meaning either the chronological age, if not mental or does not have any intellectual disability, or the mental age if the offended party has a mental disability. So, hindi lang yan tungkol sa chronological age, but also the mental age should be also be considered as well. Okay, and number two, there should be carnal knowledge, which the prosecution has established as observed by the RTC and the Supreme Court and the CAO, of course, also. Okay, so that is for ruling number one. So AAA is a mental retardate making XXX guilty of statutory rape. Okay, given that AAA is a mental retardate, we now go to number two. Yeah, it is XXX defense that they were sweethearts. Okay, XXX and AAA were sweethearts. So should that be given credence? The court said through Justice Mario V. Lopez, no, XXX sweetheart defense should not be given credence. As an affirmative defense, the sweetheart jury must be supported by convincing evidence such as mementos, love letters, and photographs. However, XXX theory of consensual sex is barren of probative weight. He failed to substantiate his claim and offered only self-serving assertion. So siya lang naman, siya lang yung delulu. Okay? So yung victim, mental retarded, eto din siya, si XXX, may pagkadilulo, okay, na sinasabi na sweetheart daw sila. Pero wala na bang pruweba, kaya nga delulu siya. Lakas maka-Gen Z, alam ko pa rin yung ibig sabihin ng delulu. Okay? Further, the testimony of the accused close relative is necessarily suspect and cannot prevail over AA's unequivocal declaration that XXX did not court and was not even her boyfriend. Even assuming that they were in a relationship, XXX cannot force AAA to have sex against her will. A love affair neither justifies rape nor serves as a license for love. Saktong-sakto, Women's Month, di ba? Eh, hindi ibig sabihin na meron kayong relasyon, eh pipilitin mo siyang makipagtalik. Okay? Of course, we should respect our women and their consent. Okay? Even you are sweetheart with them, should be that the sexual relationship should be consented and should be respected. Kung ayaw niya, ayaw niya. Kung gusto niya mag-wait kayo dahil sabi ni God. Okay? So, ayan, may kanya-kanyang desisyon sila. Huwag natin silang pilitin. Okay? In respect to our women. Okay? Pasok ang Women's Month dito. Again, in addition, the filing of criminal charges are not acts of women savoring a consensual coitus, but that of a maiden seeking retribution for the outrage committed against her. Okay? So, sinasabi lang dito ni Justice Mario V. Lopez na hindi hindi ito revenge na case, okay? So, meron talagang pinanggalingan 'to, okay, na case na 'to, na meron talagang right si A na kasuhan si XXX. And of course, since this is it was ruled that this is a statutory rape, okay, whether or not they were sweetheart, okay, whether or not there was consent, eh, wala na yun. Kasi nga statutory rape na 'to, being this is a statutory rape, eh, while regardless of consent, eh, rape pa din yun, okay? Kasi nga statutory. Okay? Kasi wala ngang consent talaga kasi ang na-rape ay isang bata na below 12 years of age or a mental age of 12 years and below. Below 12 years, okay? Okay? So yan, ingat tayo doon sa wordings, okay? Dapat below 12 years of age. Pero mamaya i-update natin yan, of course. Okay? Number three, no the issue is whether or not XXX can be charged of qualified rape. Justice Mario V. Lopez and the Supreme Court said, no, XXX cannot be charged and be guilty of qualified rape. Notably, XXX was charged, with rape committed against a mental retarded, qualified by the circumstance in Article 266B, paragraph 10 of the RPC, that the offender knew of the victim's mental disability at the time of the commission of the crime. The penalty for qualified rape is death penalty. However, in this case, the prosecution failed to prove beyond reasonable doubt that XXX was aware of AAA's mental disability at the time he committed the crime. Okay? In People versus Nebres, the fact that the accused did not dispute the victim's mental retardation during trial is insufficient to qualify the crime of rape. This does not necessarily create moral certainty that the accused knew of the victim's disability. Here, XXX consistently denied that AAA is not a mental retarded because she spoke well and can perform basic household chores. The prosecution did not controvert XXX denial and allegation that AAA functioned like a normal person. Thus, we cannot conclude that XXX had a knowledge of AAA's mental disability and took advantage of it at the time he committed the rape. It is settled that the qualifying circumstances must be sufficiently alleged in the information and proved during trial. Otherwise, there can be no conviction of the crime in its qualified form. Okay, so although it was ruled that it was a statutory rape, however, the prosecution failed to prove the qualifying circumstances that XXX knew of AAA's mental disability. Medyo contradicting lang dun sa sinabi niya dun sa sa first issue kasi sabi dun sa RTC na ruling, eh, parang parang mahirap isipin na um, hindi niya alam na mental retarded siya dahil magkapitbahay sila. However, the Supreme Court reversed that na sabi, kailangan pa ring i-prove, okay? Hindi hindi mo desisyon 'yon, judge, sabi ng Supreme Court na, magsabi kung, qualified siya o hindi, okay? Kasi nga hindi, ang yung pag-prove nun ay nasa burden ng prosecution, which they failed to do. Although they were, successful in, saying that this was a statutory rape, okay? So I hope that is clear. Number 4, whether or not the phrase of without possibility for parole is proper. Okay? So the court ruled through Justice Mario V. Lopez, no, the phrase without possibility for parole is not proper. Okay? So kailangan pa ba kasing sinasabi na without possibility for parole dun sa decision? Oh, so sabi ng Supreme Court through Justice Mario V. Lopez, all told, XXX is guilty of statutory rape, applying Article 266 of the RPC. The CA and RTC correctly impose the penalty of reclusion perpetua. However, the phrase without possibility for parole in the dispositive portion of the RTC's decision must be clarified. In AM number 150802 SC, this court said the guidelines for using the phrase without eligibility for parole to remove any confusion to it. Okay? So, ito yung guidelines daw. Kung kailan mo lang pwedeng gamitin yung without possibility or without eligibility for parole. Okay? In cases where death penalty is not warranted, there is no need to use the phrase without eligibility for parole. To qualify the penalty of reclusion perpetua, it is understood that convicted persons penalized with an indivisible penalty are not eligible for parole. So, sabihin kung hindi naman for death penalty or hindi ang penalty is death penalty, pero reclusion perpetua, hindi mo na kailangan banggitin na without possibility or eligibility of parole. Okay? understood na daw yun. Okay, wag mo nang idagdag. Yun yung sinasabi ng court. And number two, and when circumstances are present, warranting the imposition of the death penalty, but this penalty is not imposed because of the suspension of the death penalty, the qualification of without eligibility of parole shall be used to qualify reclusion perpetua in order to emphasize the accused should have been sentenced to suffer death penalty, but not because of the suspension of the death penalty. So meaning, kung ang original talaga or ang dapat na sentensya is death penalty, kaya lang hindi mo lang ma-impose yung death penalty kasi nga suspended ito, doon mo lang pwedeng gamitin daw yung phrase na without eligibility for parole. This is to in lieu, okay, para to qualify daw na this is to be substituted with reclusion perpetua. Okay, so yun. So kung again, kung hindi naman death penalty ang talagang sentensya, okay, hindi mo na kailangang at reclusion perpetua talaga ang tamang sentensya, hindi mo na kailangang ilagay yung without eligibility for parole. However, kapag yung ang sentensya talaga is death penalty, kaya lang hindi natin magagamit muna kasi nga suspended pa rin ito, okay, and that in lieu of that, yung reclusion perpetua na lang, dun mo papasok yung without eligibility of parole. Okay? Sana malinaw yun. Hence, there is a need to qualify that the accused is not eligible for parole only in cases where the imposable penalty should have been death were it not for the enactment of RA 9346 or Anti-Death Penalty Law. Okay? So, ayun, inunahan ko lang si Justice. Sorry na, Justice. Okay? XXX is guilty of statutory rape, penalized with the reclusion perpetua. Okay? Hindi naman death penalty. And there is no need to indicate that he was ineligible for parole. Okay? So, dun papasok sa instance number 1. XXX is ipso facto ineligible for parole because he was sentenced to suffer an indivisible penalty. So given na daw yun, okay, no need to indicate without eligibility for parole. Okay? So malay natin lumabas sa bar exam natin na whether or not na yun nga yung issue. Okay, yun lang yung tanong kung tama ba si RT judge for saying or for indicating in his ratio decidendi in the dispositive portion the phrase eligible for not eligible for parole. Okay, so dito papasok sa case na to yun. Okay, so tandaan yung case na to. And all other cases as well penned by Justice Mario V. Lopez. Okay? And lastly, number 5, yes, the CA is correct in modifying the awards for damages. So, minodify kasi ni CA yung damages. Hindi ko lang nalagay sa digest. Pero, Justice Mario V. Lopez said, as to the awards of damages, the CA properly modified the amounts to conform with recent jurisprudence. Okay? In People versus Hugueta, we held that when the circumstance called for the imposition of reclusion perpetua only, there being no ordinary aggravating circumstance, the victim is entitled to 75,000 civil indemnity, 75,000 moral damages, and 75,000 exemplary damages. Lastly, in line with the current policy, the CA also correctly imposed the interest at the legal rate of 6% per annum on all monetary awards for damages from the date of the finality of this decision until fully paid. Okay? Kasi ano nga ba yung naging decision ng RTC or naging um, penalty na binigay? Okay? Ang sabi dito ng RTC is 75 moral, 50 75 civil, moral damages for 50, and exemplary damages for 30. So, ang ginawa ni CA is ginawa niya 75 for civil indemnity, 75 for moral damages, and 75 for exemplary damages. So, inakyat niya, okay, to conform with recent jurisprudence as in the case of People versus Hugueta. Okay? So, yan. Um, other discussion under this is, of course, this is a 2020 case, okay? August 27, 2020, okay? Baka may magsasabi, outdated ka na, sir, kasi ano, hindi na 12 years old, okay, yung statutory rape, which is correct, 'di ba? Nagkaroon na ng amendment sa law, okay, which is Republic Act 11648, sorry, or the act increasing the age for determining statutory rape, okay, which was signed by the President on March 4, 2022. Okay? Kakaano lang yan, kaka 2 years lang yan. Okay? The long-awaited law raises the age of sexual consent from 12 to below 16 years old. Okay? So, I'm reading from the press release of the Senate of the Philippines. Okay? This was an interview from Senate President Subiri, wherein he said that at 13 or 14, our kids cannot make informed decisions about sex yet, especially sex with adults. So this is a really important law that will protect our kids from malicious individuals who intend to take advantage of them. Okay? So, because yung setting dati, di ba, given na ang statutory rape is 12 and below, below 12 years old, okay? Below 12 years old. Ibig sabihin, kapag 13 ka na, pwede mo nang gawing depensa ng nagkaroon of before this law, okay, before the increasing of the statutory age, pwedeng sabihin or pwedeng maging defense, okay, kapag 15, 13, 14, di ba? Pwedeng maging defense ng accused is na merong consent, mag-sweetheart kami, ganun, di ba? Dahil sa law na to, okay, signed on March 4, 2022, children who are below 16 years old, okay, 13, 14, 15, and 12, hindi mo pa rin puwedeng gawing, depensa yung consent kasi it is still considered as statutory rape, okay? Kasi wala pa nga daw silang tamang pag-iisip to consent to sex, okay? So, sabi dito, when the offended party is under 16-year-old, it defines rape as a person against another person instead the previous definition that specify rape between a man and a woman. So ibig sabihin hindi na rin naka-specify din sa batas na sa bagong batas, sa amended, na man and a woman lang yung rape. Okay, pwedeng man on man, pwedeng woman on woman. Okay? So yeah. So with this law, we will be definitely drawing a line that adults cannot cross. They cannot say a kid below 16 gave consent. That is statutory rape, plain and simple. And victims and their families will no longer have to prove that they were coerced. The onus will fall completely on the perpetrator. So ito yung isa pa yung pinakamagandang move ng ating legislature, okay, increasing the age for sexual consent. Okay? So, bawal pa rin makipag-sex, okay, whether with consent or not, ang children below 16 years old. Okay? So, ayan, be careful. Okay, lalo na ngayon yung mga bata ngayon, hindi natin alam kung anong tsura nila, di ba? Minsan, mature na yung mga mukha nila, pero below 16 pa rin naman sila. Okay? So, ayan, huwag papatol bigla-bigla din. Okay? Para hindi tayo makasuhan din. Okay? So, I hope, to summarize, sorry, the people of the Philippines versus XXX, again, Justice Mario V. Lopez said that there is statutory rape and the term 12 okay, 12 years of age, but that this time under 16 years of age should not also only based on the chronological age, but also there should be a consideration of the mental age of the person. Given that a person who is already older, okay, in his or her chronological age may have a mental age of below 16 years of age. Okay? Nirevise ko na kasi nga nabanggit ko na yung amended law. Okay, number 2, of course, the sweetheart defense. Dapat there should be, okay, supporting and convincing documents like love letters, notes, and photographs. But again, if it's statutory, kahit sweetheart mo pa yan, hindi mo pwedeng sabihing may consent kasi nga statutory yun. Okay? Number 3, in order for there to be a qualified rape, the prosecution should establish that the accused took advantage of the fact that the victim is a mental retardate or a minor. Okay? So, yun. Or a mental retardate talaga. Number 4, Justice Mario V. Lopez outlined when should the phrase without eligibility for parole be used. Okay, again, you could only use the phrase without eligibility for parole for in the dispositive portion when the original penalty is death penalty. However, since it is the death penalty is suspended, therefore, in lieu of that, reclusion perpetua, then you can qualify na without eligibility for parole. Okay? Pag hindi naman death penalty talaga yung talagang prescribed penalty, o reclusion perpetua lang, no need to qualify without eligibility for parole. I hope that is clear. And of course, the awards for damages should be in conformance with the recent jurisprudence. Okay, again, maraming salamat sa pakikinig at pag-subscribe. This is episode 21. Please wait for episode 22. Siguro bukas. Okay, I hope natutuwa pa rin kayo sa boses ko at sa ating ano, pasensya na kung matagal-tagal ako nag-upload, naging busy lang po tayo. Pero again, if you like this recording and also all other episodes that we have, all 20 other episodes, ayan, please like, share, and subscribe to this channel for more, 'di ba? Since again, as I promise, for every 50 in increase of subscribers, magdadagdag tayo ng dalawa. So we are already at 420. So when we reach 450, 30 na lang, magdadagdag ulit tayo. So sabihin, madadagdagan din yung backlogs ko, pero okay lang yun. Okay? So maraming salamat po sa pakikinig. Happy aral sa ating lahat at mag-apply na po tayo sa bar application. Paalam.